victims of these horrific crimes. So we are all for making sure that we hear from everyone. I don't care if you're a Democrat. I don't care if you're a Republican. I'm tired of rich people trying to evade justice and accountability, period. But you can't do it just for the party you disagree with. You can't do it in a politically motivated way. So here's the opportunity to show it's not a politically motivated thing. Let's also make sure that we get these documents from Mar-a-Lago. So with that, pursuant to Clause 2K6 of House Rule 11, I move that the House shall subpoena the Mar-a-Lago Club and all entities under common ownership or control with the Mar-a-Lago Club to provide the House Committee on Oversight and Government Reform with 1. All documents, communications, and materials related to Jeffrey Epstein, to include but not limited to personnel files and records, client files and records, massage and spa services records, complaints and grievances filed against Jeffrey Epstein, internal communications, and billing statements. 2. A list of all Mar-a-Lago Club personnel who provided massages on behalf of the Mar-a-Lago Club between 1997 and 2003, regardless of whether such personnel were contractors or formerly employed masseuses or otherwise. And 3, a list of all Mar-a-Lago Club personnel who were employed as or acted as managers of the Mar-a-Lago Club Spa between 1997 and 2003.
A motion was made by Mr. Frost. The motion is improper as the item is not on the agenda. Any other chair recognizes?
So Mr. Chair, you want to use procedure to push back accountability?
No, we're holding people accountable today. That's why we're here.
Well, why won't you move to make sure that we get the relevant documents from Mar-a-Lago? That I just read this, and you're saying it's because it's not on the agenda that we can't move forward with this? You have full discretion of this committee to say, you know what, let's have a vote in a bipartisan way to say we want the documents from Mar-a-Lago.
I don't have full discretion. It's in the rules. We vote on a rules package at the beginning of
You're able
Congress.
to say right now that we can vote on this.
We cannot vote on it. It's in our rules. We'll be breaking our rules. We have to apply to the rules too. We're not like the Clintons.
No. You are hiding behind process to protect these Mar-a-Lago documents, and I think it's disgraceful.
Chair recognizes Mr. Cloud.
Thank you, Mr. Chairman. One thing was noted in the Clintons' letters is they said the subpoenas were illegal. I'd be curious to know if the ranking member thinks that they're illegal. And with that, I'd yield the rest of my time to you.
Thank you, Mr. Cloud. I want to make sure everyone is aware. On February 11th, Attorney General Bondi will be appearing as a sole witness in front of the Judiciary Committee. Ms. Crockett is a member of the Judiciary Committee. I would assume, I don't want to speak for Ms. Crockett, but I would assume you'll ask her questions about the Epstein investigation and her progress towards releasing the documents. Mr. Massey is a member of the Judiciary Committee. He's already stated publicly he's going to spend his 5 minutes asking the Attorney General about the Epstein documents. So the Attorney General is slated to be in front of Congress, and I'm pretty confident that just about everybody on that committee is going to ask the Attorney General where we are with the document production. So I think that's important to note. February 11th, she's slated to be in front of the Judiciary Committee. And with the discharge petition, when the House voted for that, we issued the subpoenas for the Epstein documents. Then we all voted for the discharge petition. The discharge petition has jurisdiction in the Judiciary Committee. So she's going to be in front of the Judiciary Committee. The next week we're in session. So I think that's important to note. Do any other members seek? Okay, Mr. Lynch, then, yeah, go ahead.
Thank you, Mr. Chairman. I would remind the gentleman, and I'm sure he knows this, that the Oversight Committee is the principal investigatory committee in the House. And we have a responsibility. It may be a shared responsibility with Judiciary, but we nevertheless have a responsibility. And we are the ones who issued that subpoena. This committee did. We are the ones who sat with the victims, right? We looked them in the eye, including the Speaker of the House. We looked them in the eye, these women who have been struggling to get justice for many, many years, and we promised them, every member of this committee, we promised them that we would do everything under our power to make sure they finally receive justice. And here we are today. Now, with millions and millions of documents requested back in August. We've still received, what, 1% of the documents? This is evidence of wrongdoing in many cases. And yet we're allowing Attorney General Bondi to obstruct justice, basically. Even the little bit of evidence that she has provided, she also included a statement that basically said, don't believe this evidence, there's a lot of falsity in these. I mean, I have never seen an attorney general in this country provide evidence and then give an opinion on that evidence to the legislature, to the Congress. That is unheard of. But it shows her willingness to do whatever she can to obstruct justice from being delivered. The second thing I want to say is, if we are truly interested in getting information relative to this investigation, there should be some underlying basis for that. And I have reviewed all of the evidence that's been made available so far. I find nothing that points to Secretary Clinton in this at all. Yes, she was Secretary of State at one point, but the information that we're trying to get with respect to Secretary of State is available from any Secretary of State that served in that office with respect to trafficking. So there is no direct reason, no direct evidence to point to Secretary Clinton in any of this. And yet, while those millions of documents are being denied us, we're pulling someone forward, I think, for the point of embarrassment, public embarrassment, and because of a ill will on the part of the president, to bring her forward for embarrassment, but not for the purpose of gaining helpful information for this investigation. Mr. Chairman, I'll yield the balance of my time to the ranking member, Mr. Garcia.
Thank you, Congressman Lynch. Mr. Comer, I just want to be just pretty clear about two things, and one particularly something that you said. Let me just start by saying that you noted in your comments that your concern and your biggest concern was the issue of the transcript. And I want to just go back really quick, because you and I share respect for subpoenas. You and I share that we want the former president to answer questions. Is that correct?
Correct.
Great. And so does every other member of this committee. We want the former president to answer questions of this committee. And we want not just the former president, but everyone to follow subpoenas of this committee. So let's agree on that. But to be clear, President Clinton, the former president, has submitted a signed declaration. He's offered to sit with you and me and answer questions. He's offered to have staff in the room to transcribe and be there while those questions are being answered. And his request was to do it in a dignified way. Your concern, as you brought up in your last comments, was that he was unwilling to do a recorded transcript. That's actually also not true. And to be clear, there's been public reporting, including in articles that came out over the weekend, that they have not ruled out a recorded transcript. I want to ask the president questions. Chairman Comer, I want to ask President Clinton questions. Don't you?
That's why we're here.
I want to ask President Clinton questions and a recorded transcript and with our members of our staff. Would you like to do that also?
May I make a comment on the transcript? They have not agreed to a transcript. Staff notes are not equivalent.
They've actually made public reporting.
So they're wanting me to make note. They said, okay, Comer can take notes, but they've called us all liars, and you know how the Clintons have gone on offense, and look, they don't get to make the rules. We make the rules.
Can I have the rest of my time back?
Yeah.
Okay, thank you. I want to be clear, because this is an email actually that from the Clinton lawyers. You have this actually. To be clear, at no point were we opposed to the creation of a record of the interview, which is why we offered to allow the note takers previously. They go on. You have this email, sir. So I guess my question to you is, do you want to sit down and ask President Clinton questions? Actually, can I have my time back?
Will the ranking member we'll recognize Garcia, then Mr. Donald will be next. So
thank you. So my question to you, Mr. Comer, again, is if we want to actually ask questions of President Clinton, of which those of us in the minority want to do, then let's get him in. Let's negotiate a recorded transcription of that interview to further our investigation. I thank you for the yield, Mr. Lynch.
Chair, time's expired. Chair recognizes Mr. Donalds.
Yeah, Chairman, point of clarification. Both President Clinton and Secretary Clinton were subpoenaed by this committee to come in for a transcribed interview. Is that correct?
For a deposition.
Excuse me, for a deposition. Chairman, I've been in these closed depositions a number of times in my time being on the Oversight Committee. I fail to see what President Clinton's talking about with respect to a dignified manner. Every time I've been involved in any of these conversations, even when it was former President Biden's son came in for one of those, and I'm not trying to bring up all the Hunter stuff. It's just a point I'm making. I think everybody just take the temperature down, relax. Even those the closed door depositions have always been held in a dignified manner. Members have had questions outside of questions from committee staff, but members on both sides of the aisle had an ability to answer those questions. Those interviews are recorded. The transcripts of those interviews are provided to the public. I fail to see what special accommodations President Clinton and Secretary Clinton were looking for. Chairman, can you help me understand this? Or even a ranking member. I'm really trying to understand. I'm not trying to make a point. We do too much of that here. I'm trying to understand, because if we're holding a new meeting to replace what the committee already requested, my question is why?
Mr. Garcia is willing to answer the question.
Yeah. Thank you, Mr. Donalds. I appreciate the question. Look, I think the committee first, I'm not here to defend the Clintons, to be clear. That's their job is to negotiate with the committee, and in this case, you have the majority. Their job is to negotiate with the majority on coming in for a binding subpoena, to be clear. But I'll also note that this committee has historically made accommodations for a variety of folks. In fact, I think it is a bit hypocritical that when this very subpoena for the Clintons were actually made, I believe there were an additional 5 to 6 other subpoenas that were issued to numerous other members of former administrations, attorney generals, and so forth. Every one of those other subpoenas, I think maybe with the exception of one, were given special accommodations. In fact, they were actually allowed to just send their responses in writing. Is that correct, Mr. Comer?
That is. May I respond to that?
Yes, in just 1 second. And so accommodations are made. And so while every other folks in that group were given special accommodations, that's been typically the case. And I'll finally say just this. Like you, I want to have President Clinton answer questions. I think they are trying to negotiate that with the majority, and they have been clear that it being transcribed is not an issue. They've not ruled that out. And so let's negotiate with the Clintons and let's get them to answer our questions.
Chairman, since I guess we're on my time, and by the way, ranking member, thank you for that. I appreciate that. Chairman, you were mentioning you were going to inject your commentary with respect to special accommodations that have been made for previous witnesses. I don't know if you want to expound on what the ranking member said or not.
I would love to. So, first of all, you talk about ongoing negotiations. We have been negotiating for 5 months. This is clearly a stall tactic, hoping that the time clock runs out and the House flips and that you all let them off the hook. But secondly, you mentioned, and I mentioned this in my open statement, there were names on that initial list with the Summerlee motion and the Scott Perry amendment. Attorney General Holder, Lynch, Sessions, and Garland, as well as Comey, they all complied and had written statements under the penalty of perjury that they had no knowledge of anything with Epstein, that they weren't directly involved in the investigation and basically had no personal relationship. I think we would all agree the Clintons had a personal relationship with both Epstein and Maxwell. It's from the evidence that we've received thus far from the estate and all the other documents that we have thus far, it appears that Jeffrey Epstein visited the Clinton White House 17 times while he was president, and then post-presidency it appears that Bill Clinton flew on Epstein's plane at least 27 times. So there's a huge difference between the knowledge and relationship with the Clintons and Epstein and Maxwell versus the former attorneys general. And another note, I don't know if it was Mr. Bell or whoever said that we only are interested in Democrats. We grilled Bill Barr and Alex Acosta, and they are very Republicans. In fact, they were members of the Trump cabinet. Now, I've been on the Oversight Committee 9 years. We've had 4 other committee chairs. We've had Jason, since I've been here, we've had Jason Chaffetz, Trey Gowdy, Elijah Cummings, and Carolyn Maloney. I don't ever remember a time, and I could be wrong. If I am, I'm sure you all will correct me, but I don't remember a time when Carolyn Maloney or Elijah Cummings subpoenaed a high-ranking Democrat to come in for a grilling. So to imply that this is partisan, that is just simply not true. We've already had 2 very high, the former Attorney General of the United States under Trump and the former Labor Secretary and U.S. Attorney. So we've done that. And then one other thing with the Clintons, and I'll yield back. One of the arguments the Clintons made, Mr. Garcia, was that our subpoenas were unlawful. Do you agree that the subpoenas we issued the Clintons are unlawful?
I believe that all of our subpoenas that we have issued have been lawful, sir.
Okay. Just any other members seek recognition?
Ms. Brown, sir.
Ms. Brown. Ms. Brown.
Thank you, Mr. Chairman. It's clear to me that the purpose of this meeting today is just to continue this committee's agenda of political theater, plain and simple. Democrats have been very clear, abundantly, repeatedly, and without room for ambiguity. We want to hear from anyone who has information about the Epstein crimes. And yet, when former President Clinton and former Secretary Clinton offered to cooperate with this committee, to submit sworn statements, to provide what they know, to engage in good faith, the majority said no. And that's what brings us to why we're really here today. The majority is rushing to hold in contempt 2 private citizens who have demonstrated their desire to cooperate with this committee and who have called for the release of every file on Jeffrey Epstein, all while the Department of Justice and Attorney General Pam Bondi are breaking the law in plain sight. Here are the facts. The DOJ was required by statute to release the Epstein files by December 19th, 2025. The deadline has passed by more than a month. And what have we received? 1%. 1% is not compliance. 1% is not transparency. 1% is a cover-up. What about the 1% they actually release? We've seen redactions that are extensive, unusual, and very likely illegal. And what's more, the Epstein Files Release Act, passed by supermajorities in this Congress and signed into law by this president, required the DOJ to send a report to Congress by January 3rd, 2026. More than 2 weeks later, what have we received from the DOJ? Nothing. So if my colleagues on the other side of the aisle were really serious about uncovering the truth and government and accountability, we would be demanding answers from the administration. We would be demanding answers from Attorney General Bondi. We would be demanding the release of the 99% of the Epstein files still sitting at the DOJ. So I have some very simple questions. Where is the subpoena for Attorney General Bondi? Where is the hearing on DOJ's failure to comply with the Epstein Files Transparency Act? Where is the accountability for the redactions page after page after page? This vote feels less like oversight and more like a distraction. A distraction from the DOJ's lawlessness, a distraction from a broken promise of transparency, a distraction from the embarrassment of a co-equal branch of government choosing complicity over accountability, and a distraction from survivors who deserve this truth. If this committee is serious, then we must hold the Department of Justice accountable. Release the files, all of them, and stop playing politics with justice. Survivors deserve better. And with that, I yield the balance of my time to the ranking member.
Thank you, Representative Brown. I just want to Chairman, I want to just respond of who the subpoenas you have chosen not to enforce. Alberto Gonzalez, who we subpoenaed on that same day, I believe you did not enforce. Eric Holder, of course, former AG, did not enforce. Loretta Lynch, you chose not to enforce. Jeff Sessions, you chose not to enforce. Merrick Garland, who I think it'd be important to have answer questions, you chose not to enforce. Robert James Comer, you chose not to enforce. In fact, I have Attorney General Gonzalez's letter. It says, "Dear Chairman Comer, this letter is to confirm that consistent with my conversations with the committee general counsel, I have no present memory or decisions or conversations related to the investigation and prosecution of Epstein matter during my tenure as U.S. Attorney General." He, of course, was the Attorney General when the whole Alex Acosta U.S. Attorney matter was in front of a critical time in this investigation. Now, you chose not to enforce that because you mentioned that this letter is under penalty of perjury. The declaration that Clintons also made and sent to you to answer some of those questions were also under penalty of perjury. I just want to clarify that. And then with the remainder of my time, Mr. Chairman, I think it's important to note that you talked a lot about the importance of our subpoenas and that we should all support this committee's subpoenas. And I agree with you, sir, and I want to hear from the Clintons. It's also important to note that we have members of this committee, Congressman Jim Jordan, Congressman Andy Biggs, Congressman Scott Perry, who are obviously very outspoken, which we like to engage with. Now, they're not here, and that's okay. Now, you also know, sir, that all three of them defied legally binding subpoenas issued by the January 6th committee relating to their efforts to overturn the 2020 election. So we should be clear that the majority chooses to be very selective on which subpoenas they want to enforce or talk about. We have members of the majority that themselves have defied subpoenas. So once again, I ask you, Mr. Chairman, let's ask President Clinton the questions that we have. Let's have him come in and testify in a way that we can negotiate, and let's get all the release of the files done immediately. Thank you.
Would you yield? Could I respond to that?
Sure, I have no more time, but I'm happy to respond.
So you say we didn't enforce the subpoenas. We did enforce. They complied and testified under the penalty of perjury that they had no knowledge. Now, the Clinton declarations were short bullet points, almost like talking points. And the evidence is clear that the Clintons did have relationship with them. Now, again, I've said publicly millions of times, there's no one's accusing the Clintons of wrongdoing, but the fact that they were that close, and the fact that I've never seen a sit-down interview with Bill Clinton where he's answered questions about his relationship with Epstein and Maxwell like the current president has. So we have complied and enforced all of our subpoenas, 100% of our subpoenas. So I just want to make that very clear.
Can I respond to you, sir? Sure. Just to be clear, you're talking about two declarations. The declaration that you chose to use as something that you moved on to not bring him in was 1/6 the size of the Clinton declaration. I'm looking at the Alberto Gonzalez response to you, sir, that you chose to dismiss, and it is one sentence long. You just pointed out the Clinton declaration, which is 6 times as long. And so I just think you are using interesting points to make comparisons. Let's just be clear and get back to the facts. Let's bring President Clinton in to have a conversation with this committee. You are instead choosing to try to prosecute President Clinton and send him to jail, which is part of criminal prosecution, before having him answer questions to this committee. Him and his team have been trying to negotiate. We want to hear from President Clinton. I'm not sure that you do, sir.
You don't think I want to hear from President
Chairman
Clinton?
Comer, can I, Chairman?
But before I recognize Ms. Luna, who'll be next, I believe, are you willing to accept those bullet points as testimony, or do you want to hear from Clinton?
I want to hear from President Clinton.
Then I don't know what the point is of talking about their bullet points. I mean, that we all know they had a relationship. So.
Well, sir, I'm just responding to the fact that you mentioned that you're dismissing other legal subpoenas with 1-sentence answers, and you're the one that pointed out the Clinton's declaration, which is also under penalty of perjury.
Do you think that Eric Holder or Lynch or Jeff Sessions or Merrick Garland had more? I mean, do you want to bring them all in?
I would love to have former Attorney General Merrick Garland in front of this committee to answer questions as to why more of the files weren't released. I've actually said that publicly. And so, sir, I think what it comes down to is we all want to get to the truth. We all want justice for the survivors. And I think more information is better. And so I think our position is that it is clear to me that President Clinton is negotiating to come in front of this committee. And it may not be exactly what you and the lawyer and your team want to see as far as that negotiation, or you're not satisfied with the progress, but they continue to negotiate. They have not rolled out a transcript. Let's get them in front of this committee. Thank you, sir.
Chair recognizes Mr. Gill, then Ms. Luna. Mr. Gill has a bigger. Go ahead. No, Miss. Who's next? Ms. Luna. Go ahead, Ms. Luna. Then Ms.
Thank you,
Mays.
Chairman. I'd just like to remind the American people that I was the member that made the motion to hold Merrick Garland in contempt of Congress, and every Democrat voted against it. And in addition to that, 3 of my Republican colleagues voted against it, one of which did not come back because his voters decided that he was too swampy for them. So
Okay.
I just like to point that out. But aside from that,
Well, Ms. Luna, it's been pointed out to me you've already had 5 minutes. Somebody will probably yield you some time, so I've got to.
If I could just finish real quick. If we're looking to see why the files have not been released yet, look no further than the judge, Engelmeyer,
I'm sorry,
who's
Ms.
actually been
Luna.
responsible
I'm sorry.
for
If
denying
someone can yield you some
Massey's
time.
special counsel. I'm just saying, I'm making a point.
All right.
So this is all political
So we haven't
games
recognized
here.
the Republican on this. Miss Mace, do you want to be recognized?
That would be great, Mr. Chairman. I have a number of documents I would like to enter into the record this morning with unanimous consent. First of all, I want to ask my colleagues on the other side of the aisle to stop playing politics with justice. Not a single one of you voted for your own party to be held in contempt. I'm the only member of this body, of this committee, that has held both Republicans and Democrats alike in contempt for defying a congressional subpoena. So the hypocrisy is real, and I don't want to hear anyone on the other side of the aisle say no one is above the law here on this. We're talking about human trafficking, sex trafficking. We're talking about children, girls as young as 14 being assaulted, being trafficked by wealthy and powerful people. This is not political. This is personal. This should be nonpartisan. We should be working on this together. And it's incredible that we're politicizing rape, or politicizing sex trafficking, or politicizing this entire Epstein thing. And it just, as a survivor, I'm telling you, it should not be. And I've done a lot of work, Mr. Chairman, in advocacy and writing legislation for victims of abuse, male, female, and children, man, woman, and child. South Carolina, my home state, Mr. Chairman, has a huge problem with with all sorts of violent crimes, but sex trafficking in my state is up by over 400%. We have domestic violence in our state where you can't get a trial. And there was a case last year where a woman 2 years ago was kidnapped by her boyfriend, beaten to a pulp, her face just beaten in. 2 years after he kidnapped her and beat her, he murdered her on Mother's Day because our local solicitor refused to prosecute that case. And I have rogue solicitors and prosecutors and attorneys general who aren't doing anything to protect the people of South Carolina, women and children especially. Recently, my attorney general prosecuted a case against convicted pedophile Donald Gresh. Donald Gresh was convicted of having 1,900 images of toddlers as young as 3 being raped by animals. Donald Gresh, under the prosecution of my Attorney General Alan Wilson, served 1 day in jail. 1 day. Donald Gresh isn't the only pedophile, convicted pedophile, that we prosecute like that. My Attorney General Alan Wilson prosecuted this case. This is Travis Reed Gay. Well, the other thing, too, is that Donald Gresh, he was facing 60 years in jail, got 1 day. Travis Reed Gay was facing 70 years, 7 charges and 70 years in jail in South Carolina. My Attorney General prosecuted this case. He pled guilty in November, didn't serve any time. He got probation. He violated his probation 11 days later, and if he violated his probation, he was to serve time in jail. The magistrate or judge, probably didn't have a law degree, let him out hours later. He has not served any required time for this kind of thing. And I did a press conference with a bunch of moms, over a dozen moms last week in Charleston, South Carolina, and there was a local media blackout. I asked, was it my attorney general who prosecuted this case and led this pedophile out on the streets? Was he the one that led the media blackout? Well, I want my attorney general in my state to know that a young child came forward after seeing my press conference and recognized this man. She filed a police report the same day because he allegedly followed her in a park the week before. This is Scott Spivey, killed, shot with a bullet in the back, shot at 17 times, not prosecuted by my attorney general. So I'm going to ask unanimous consent, Mr. Chairman, to enter those 3 images into the record. This is Weldon Boyd. This is Scott Spivey's killer who shot him in the back and has never really been investigated or prosecuted for that killing in South Carolina. I would like to enter that into the record, Mr. Chairman.
Without objection, so ordered.
This is Logan Federico. She was executed a year ago, yesterday to the day, by a man named Alexander Dickey. Alexander Dickey was a convicted criminal. He had 39 arrests, 25 felony charges. He executed this beautiful 22-year-old daughter of Stephen Federico in cold blood after stealing a gun. If her killer, Alexander Dickey, hadn't been let out by a rogue magistrate or judge or a prosecutor or solicitor that didn't care, she would be alive today. Mr. Chairman, I would like to enter her image and her killer's image into the record.
Without objection, so ordered.
I have another image. This is Eric Bowman. Eric Bowman beat his wife and has been alleged and is being investigated for other abuses against women and potentially underage girls. He was just let out free, Mr. Chairman, out of jail in South Carolina. He is a predator. I have reported him to law enforcement. He's under investigation, but I have written bill after bill about predators like Eric Bowman, about voyeurism, about these sort of criminal sexual allegations. I would like to enter his image into the record.
Without objection, so ordered.
I have 2 more.
Can we get it? Your time's expired, but I'll recognize you for a UC later on, because I want to make sure everybody stays within their 5 minutes. Chair recognizes Mr. Bell from Missouri.
You know, first and foremost, I think we're doing a disservice to the victims in this case when we refer to it as the Epstein files. It's sex trafficking evidence, and let's call it what it is. And as a prosecutor, we prosecuted these kind of cases when I was DA back home in St. Louis County, and I met with every single victim and victim's family because I wanted them to know that I was here for them, and I thought it was important that we look them in the eye and let them know that we're going to do everything we can to bring them justice and treat them with the dignity and respect that they deserve. And this is no different. That said, I think in D.C., what I've learned in my 11 months here is that this D.C. disease that of staying in this partisan bubble is something that you have to continue to be aware of, so that you don't fall into these same hypocritical traps. And I talked to Jamie Raskin because I just wanted to get some perspective on the law. And when we talk about the legal analysis, first and foremost, you can't read a statute. You learn this in constitutional law first day. You can't read a statute and understand the law. You have to understand how it's interpreted by the courts. And the courts have been clear that if there is negotiations, that does not meet the threshold for criminal contempt. And the examples are clear on that. When Steve Bannon was held in contempt, he did not negotiate, he did not reply, he did nothing. Meadows, when he started to reply, then Trump told him not to, and then he ceased with his communications with this body. And so in this case, I agree 100% with our ranking member. I want to hear from the Clintons. I think the victims we want to hear all the evidence. But what I know as a prosecutor is that we don't start doing depositions before we listen to the evidence. Now, if there's not evidence, okay, then there's other things to consider. But the evidence is here. There is evidence that has been duly voted on to be presented to the American people in a bipartisan manner, and of this evidence, we've received 1%. 1%. I mean, put this in perspective. There's 0%, and then the only thing you can do next is go to 1. That's it. We've got nothing. And now we're going to bring the Clintons in before we even have the evidence. That makes 0 sense, which is close to the 1 that I talked about. And so there's a legal analysis here. There's about what are we doing to ensure that we are doing a real investigation to get these victims the justice that they deserve. And so Ghislaine, whatever her name is, she needs to be brought into this body. And I'm hearing that, oh, well, she's going to plead the Fifth. First of all, then let her. But secondly, legally, on most of these questions, she can't plead the Fifth. On grounds that she's going to be incriminated? She's already a criminal. So let's bring her in. Let's do those things. Let's bring in every single person. I don't care what they are, Democrat, Republican, and I've said this publicly, and my mother got on me about this. I don't care if my mother is in the Epstein files. We need to see 100% of the Epstein files to ensure that we are doing right by these victims. The legal analysis does not support criminal contempt. A real investigation, a fair, bipartisan investigation would lead us to the conclusion that we want to hear from the Clintons, that we want to hear from everyone. But right now, we don't even know who else is in the Epstein evidence because Pam Bondi has not turned over that evidence. And that's the massive violation that we're seeing, that my colleagues on the other side of the aisle don't seem to have any urgency about. The massive violation of the law, and Pam Bondi needs to be here to answer those questions. But that is like, oh well, we'll put it off. We'll get there. We're working with them. I'll yield the remaining. Sorry, ranking member.
Before I recognize Mr. Gill, I want to point out February 11th, Pam Bondi will be in front of the House Judiciary Committee. February 9th. I'm sorry, February 9th. February 9th.
February 9th is Miss Maxwell.
Miss Maxwell. And February 9th, we're deposing Miss Maxwell. February 11th, Pam Bondi will be in front of this committee. So there's a lot of wheels moving right now. Chair recognizes Mr. Gill from Texas.
Thank you, Mr. Chairman. I just think it's worth pointing out that the obvious reality here is that the Clintons are doing everything they possibly can to not come testify before the committee or have any real transcript or information about his engagement and involvement with Jeffrey Epstein over a long period of time. I mean, we've been working for 5 months to nail down a date for a deposition, working in good faith in the entire time. The Clintons have been evading this committee, at one point even deciding that they were going to propose Christmas Day, Christ's birthday, as a date for a deposition. I mean, that's not good faith. At one point, they proposed that instead of doing a deposition, they're going to have Chairman Comer and his staffer and a note taker go up to New York City, where they could ask Mr. Clinton questions and create 2 different sets of records about what Clinton said. That's obviously quite different than having an official court reporter precisely write down the words from the former president. Competing staff notes are simply not going to cut it. So we've spent 5 months working on this. It's about time that they comply with a lawful subpoena like many other people have. And there's some suggestion that we're selectively choosing who to enforce these subpoenas against. I mean, as you pointed out multiple times, Jeffrey Epstein visited the White House 17 times. He flew at least 26 times on Epstein's private plane. There's a clear, long-standing, obvious connection between the Clintons and the Epsteins, and I think we need answers for that. And I hope that we get that, and I hope that our colleagues on the other side of the aisle will join us in that. And with that said, I'm happy to yield 2 minutes to my colleague, Miss Anna Paulina Luna.
Thank you. I'd like to just say that I do agree with some of the sentiment of both my colleagues, to include Mr. Bell, who actually just spoke to wanting justice for the victims. But it's important to note that the reason why the files have been delayed in release is because of Judge Paul Engelmeyer in New York. This judge specifically ordered the SDNY to do a second review, and for those documents to then be certified by U.S. Attorney Jay Clayton. So if you want to get mad at someone, look no further than Judge Paul Engelmeyer, who then also, at the same time, just denied Massey and Ro Khanna's motion to appoint a special master. So we can argue back and forth all day long about where the files. I want to see the files too. I want everyone to come in and answer questions. But look no further than this person. By the way, this person is not a Democrat or Republican. I think this person actually might be an independent. But if you're wondering where the files are at, that is the truth of the matter. That's it. As soon as those files come out at the DOJ, we're going to get them. And by the way, I will remind people that weren't here earlier, Todd Blanche will get on a phone call with people here. And after this, I'm going to go walk over Todd Blanche's cell phone number to Chairman Garcia and to Chairman Comer so they can both get on a call. I think it's important to open dialogue, okay? But the point is that we have to know the facts, and those are the facts. So look no further than Judge Paul Engelmeyer. Again, he's the one person that appointed the review, a second review, and then once those documents are then reviewed, then it goes to the DOJ. But you can't fast track the process.
Ask a question?
Yes.
Okay. Are you suggesting that the reason for not receiving 99% of these files is this judge? Not 20% of the files, 30%, half of them, 99% of the files, some of which are already public?
From what I've been told, and this is why I would encourage you guys to talk directly to the DOJ on this, is that there was a second review ordered. I don't know who all is in charge over in New York specifically doing that second review, but I do know that at least with the DOJ, they are officially done reviewing all the documents that they had left, right? They had 500 attorneys. I actually said this earlier, that NSC, Southern District of Florida, SDNY, and the FBI, there's 500 lawyers working on this to review all the documentation. They're officially done with that. Now, I don't know what the second review process is because I'm not internally at the DOJ, but what I will tell you is when you have this judge then also turning around and denying Ro Khanna and Massey's motion to appoint a special master, which I think Mr. Khanna can probably speak on, I think that that's shady. And I think that it's really terrible that we're sitting here arguing at each other, pointing fingers, when it's this one guy who no one seems to be mentioning that's actually stonewalling it. So I'm here for it. I want all the documents, and I do think that we're going to get those documents. Do I think it's going to be rushed? Absolutely not. I don't want to rush the process, but I will also encourage you guys, just as I did this morning, I got a victim's specific information. The DOJ has said that they will release whatever files they have pertaining to her directly, and she had not up until recently been able to, I think up until today, get that because, frankly, a lot of these victims' portals go to just, I think, empty inboxes. But the point is that it's important for context. So I yield my time.
A question for the chair.
Well, you're Rick.
Before I begin, I have a question for the chair. I just wanted to clarify, when you said Pam Bondi's coming on February 11th, is she coming to this committee?
She's coming to the Judiciary Committee.
So is she coming to this committee at all?
Well, we'll see how the Judiciary...
Is she scheduled to come to this committee at this point?
I've said she's not scheduled to come to the committee. She's coming in front of the Judiciary Committee.
Okay.
Chairman,
Chair, you're recognized, Mr.
I'd like to yield 30 seconds to Ranking Member Garcia.
Thank you. Just really briefly, I appreciate Representative Luna's interest, I know, in the survivors. So I do appreciate that. I just want to be very clear and clarify. Judge Engelmeyer has nothing to do, his rulings have nothing to do with the legal subpoena passed by the Oversight Committee last July. Pam Bondi and Todd Blanche and the DOJ have been in defiance of a legal subpoena of this committee that has nothing to do with the Khanna-Massey law that keeps getting referred to. And so when you're saying that Judge Engelmeyer is the reason, that is actually not the case as it relates to the subpoena. And so they're still violating the law and have been since July, to be clear. Thank you, Mr. Min.
Thank you. And I just want to begin by echoing the comments of my colleagues on both sides of the aisle. As someone who spent my career as a lawyer, as a prosecutor, as a law professor, the rule of law is important. No one should be above the law, including presidents and former presidents, and congressional subpoenas are an important part of that rule of law. And I think the Clintons should be here. I think it's very shameful that they're not. But I also have to admit I'm very troubled by this criminal contempt motion. As a lawyer, I know that I don't know this area of law, criminal contempt. So what I did is what any decent lawyer does. I asked people who do know this area. I called a number of colleagues, former colleagues, people who are former DOJ attorneys, experts in this area. And it's hard to get 10 lawyers to agree on anything, but they all agreed that this was unprecedented, that under a normal administration, a normal DOJ that's not politicized, they would never bring criminal contempt charges in these circumstances. And I say non-politicized DOJ because many of us are very concerned that this Department of Justice has become weaponized under this administration. Under Pam Bondi, we have seen them go after Trump's political enemies, including people like Adam Schiff and Latifah James with bankrupt charges. We've seen them refuse to investigate an ICE agent who clearly shot and killed a woman at point blank. We've seen them fire line attorneys who refuse to go along with indictments that they describe as political and illegal. Now, the closest comparison to this particular criminal contempt case is Steve Bannon. And there's well-established precedent here. Steve Bannon refused to answer, saying he would only answer questions from this committee if Trump told him to do so. That wasn't like delaying or obfuscating. That is willful defiance. And that's what the courts found, and that's why he went to jail. And again, while I think that the Clintons should be here, what we're proposing here is a very serious matter, bringing criminal charges against a former president of the United States. And I listened to you very carefully, Chair Comer, for the last hour, and I heard you describe them as delaying, as dragging their feet, negotiating for 5 months. But I never once heard you say they just outright refused to comply with the subpoena. And dragging your feet is not the same as noncompliance. It's not the same as contempt. And so if we think they're dragging their feet or obfuscating, there are lesser things we can do, including civil contempt. And I have to ask, like, why are we not thinking about alternative measures rather than bringing criminal contempt against a former president? And I also want to point out that on November 14th, and I want to ask unanimous consent to enter this into the record, Donald Trump wrote a Truth Social post in which he demanded that the Republicans go after Bill Clinton, Reid Hoffman, Larry Summers in relation to Epstein. Later that day, Pam Bondi announced that they would be bringing investigations. And now that we saw later that this committee brought subpoenas against the Clintons. This seems very political, and the people I talk to in my district view this entire matter as politicized. They view this as why Bill Clinton. And look, if Bill Clinton is guilty, let's put him in jail. But what I have a problem with right now is that we seem to be doing something that is unprecedented for Bill Clinton. We're bringing criminal charges against him, potentially, that we would not do for any other individual in these same circumstances. And that, again, is not my opinion. It's the opinion of everybody I talk to. It says it's not a close matter. And so I have deep concerns that this looks like a political witch hunt against Trump's critics, that it will be referred to the Department of Justice, that we have seen as politicized. Many of us had deep concerns that they are breaking the law on a daily basis. So I have trouble with this. I don't know yet how I'm going to vote, but I'd love to hear from you, Mr. Comer, why we did not pursue alternative measures, particularly when the Clintons, by all accounts, were actively negotiating. And whether you thought that their offers were not sufficient, they don't strike me as noncompliance or defiance of this subpoena.
Mr. Min.
Mm-hmm. Mr. Min, will you
think
yield for a
for
question
5 months? I mean, you just want to keep negotiating for 12, 11 more months and hope.
Willful noncompliance is my question to you.
I mean,
why not civil contempt or
nobody's
something like
buying what you're selling. We've been negotiating for 5 months.
Why not civil contempt or some alternative?
Can I make a suggestion, actually?
I don't yield my time to you. I yield it to Mr.
I've already answered your question.
I yield back then.
All right. Chair now recognizes Mr. Higgins.
Thank you, Mr. Chairman. Request unanimous consent to enter into the record the minutes of a hearing conducted by the Federal Law Enforcement Subcommittee on July 23rd of 2025, over which I presided as chair. That was the subcommittee, to clarify for America, where the original subpoena driven by the Democrats and Ms. Lee, the original motion to subpoena the so-called Epstein files was introduced. Unanimous consent to present.
Without objection, so ordered.
So within that is minutes. Here's the original motion from the Democrats. Move that the subcommittee issue a subpoena. Listen carefully, you alleged journalist and the beloved American citizenry that's paying attention to this. move that the subcommittee issue a subpoena to the Department of Justice for the full, complete, unredacted Epstein files to be delivered concurrently to the majority and minority of the Subcommittee on Federal Law Enforcement of the Committee of Oversight and Government Reform. That's it. That was the motion presented by the Democrats. That motion immediately struck me as very poorly written because it had no recognition of recognizing and adhering to the existing long-standing criminal justice procedure designed to protect the innocent. It had no timeline. There was no timeline mandated in their own motion that would force the DOJ to comply with said timeline. There was no mandate for a particular percentage of release. There was no prohibition for actions in performance of compliance with their motion, which would become a subpoena from the Oversight Committee. It was not even the identification of Epstein. It just said Epstein files. Epstein who? You think the DOJ has not prosecuted more than one Epstein in the history of the DOJ? It was very poorly written. So, Republicans, noting that there were a lot of people missing from this, if we were going to do this, allow it to move, there were a lot of people missing. So Mr. Perry introduced, I remind my colleagues that this is my time. You recognize the decorum of this Oversight Committee. Perhaps you'll be recognized to speak. Mr. Perry introduced a motion to amend the motion to subpoena by the amendments to include William Jefferson Clinton. Imagine that, use the whole name. And Hillary Diane Rodham Clinton, amongst others. And of everybody on Scott Perry's list, the most defiant has been the Clintons, and the Oversight Committee has been very patient. I submit for the record, unanimous consent, I ask Mr. Chairman, the actual subpoena produced on August the 5th, at a hearing on July the 23rd, the subpoena was produced on August the 5th.
Without objections ordered.
Everyone has essentially complied to the wishes of the committee. Who's in control? We are. With a majority, we determine. The most defiant has been the Clintons. That's why we're here today. Back in July, after Scott Perry introduced an amendment to the Democrats' motion expanding the list to include the Clintons and others, including Republicans, Ms. Mace introduced an amendment to the motion to subpoena, saying, I move to amend Ms. Lee's motion to include the redacting of names of victims and any personally identifiable information of said victims and any possible child sexual abuse materials. And the subpoena itself, and I'm closing, Mr. Chair, the subpoena itself stated that the DOJ is to provide all the material requested and recognizing redactions required by law. So you're talking about 1 million documents. It takes time to redact 1 million documents. But the DOJ is performing and is delivering, and the Clintons are.
I'll give Walkinshaw an extra minute.
Thank you, Mr. Chairman.
But before we go to Mr. Walkinshaw, Ms. Mace has 2 more unanimous consent requests, and I'm going to give Mr. Walkinshaw an extra minute if everyone's okay with that. Ms. Mace?
Thank you, Mr. Chairman. I want to thank my colleagues too. The whole Epstein saga and working with people on both sides of the aisle on the Epstein files and the working with the victims has been extremely enlightening.
Yeah,
This doesn't sound like unanimous consent.
You say, can you present the unanimous consent?
Oh, here's the unanimous consent.
Yeah, okay.
Through the Epstein thing, this is a tweet that I did about judges. I learned that, not all the judges have been forthcoming with information and files. I tweeted out on November 28th, impeach corrupt judges, especially South Carolina judges. I've done this about a dozen times or more. I'm guilty as charged. Last week, an attorney named Robert Murding, I would like to enter his image into the record too.
Without objection to order.
He is trying to hold me in contempt and told a judge I should be thrown in jail for, among other things, tweeting out that judges should be held in, that judges should be impeached. This is what happens to survivors. This is what happens to victims. And
I'm sorry.
I would like to enter my predator bill into unanimous consent as well.
Without objection to order. And
thank you.
All right, thank you. Chair recognizes Ms. Walkinshaw for 6 minutes.
Thank you, Mr. Chairman. I'll restate what others have said, which is that anyone who has information relevant to our investigation, including President Clinton, should talk to the committee. And I'm glad that he's agreed to do so. I have read, Mr. Chairman, that one of the sticking points in the negotiation between you and the Clintons' lawyers has been your demand that questions be asked about non-Epstein related issues. And it surprised me because I'm sitting here today listening to your intense interest in understanding more about the Clintons and their relationship with Epstein. So I'm curious why you have for 5 months demanded that you and other members of this committee be able to ask questions unrelated to our investigation of the Epstein files and Epstein's sex trafficking. And I'm happy to yield, Mr. Chairman.
I don't know what you're talking about. Everything that we've pertained to with respect to the deposition pertains to the Epstein files.
Okay, so you haven't demanded that the conversation, the questions be limited to the Epstein files.
The staff attorneys are communicating with the Clinton attorneys. That's the communication going back and forth. This investigation is about the Epstein files.
Okay, so you're willing, and you'll say here publicly, you're willing to have that conversation that limits the conversation, the questions just to the Epstein issue and files. Okay.
Yes.
All right. I think the Clintons' lawyers have been under a different impression, so we've made a little progress.
The Clinton lawyers are full of crap.
Made a little progress on the negotiation here today. Thank you, Mr. Chairman. We're 32 days past the statutory deadline and months since this committee's subpoena, and Congress has received, as we've heard, just 1% of the files. More than 5 million pages remain hidden. Instead of holding the Attorney General accountable for this failure, the majority is trying to change the subject today. Frankly, I find it insulting. We have to bring our attention back to the people who should be our focus, the survivors of Epstein's horrific sex trafficking operation, the women and girls who were exploited, abused, ignored for years. They deserve the truth, transparency, and justice without delay, without excuses, and without any political protections for the powerful or the wealthy. That's what we should be doing. Not scoring partisan points, not creating distractions, working to uncover the full scope of his crime so the survivors can see accountability. And if we're truly serious about justice, we can't ignore one of Epstein's most well-documented associates, President Donald J. Trump. We have documented communications, including a signed birthday note from Donald Trump containing explicit sexual references and referencing wonderful secrets between them. Emails from Epstein saying that Trump, quote, knew about the girls. Donald Trump acknowledging he knew Epstein was a, quote, creep and that Epstein recruited girls and women from Mar-a-Lago. Trump saying he wants to cover up the files because, quote, my friends will get hurt. If we're committed to transparency and justice, why is that off limits for this committee? Why is his name absent? Why no discussion of Attorney General Bondi's refusal to comply for months with this committee's subpoena. Why no contempt for Attorney General Bondi? What we're witnessing today is not oversight, it's not accountability, it's part of a cover-up, a diversion. And it didn't start today. Despite clear legal requirements in a law that Donald Trump signed, a subpoena that you signed, Mr. Chairman, and repeated public promises, Attorney General Bondi has failed to release the files. It's entirely within her control, and yet only 1% has been produced, more than a month late. And even that sliver is so heavily redacted that it mocks the law. It mocks the law. And it mocks this committee's subpoena. Let's be honest about the transparency that Attorney General Bondi has provided. This is DOJ Epstein data set number 4. It's number 4. Data set number 4. This is part of the 1% that folks have been talking about this today. I'll close with this. Attorney General Bondi and the Trump administration missed their deadline. They're ignoring our subpoena. They've withheld 99% of the files, and they have obscured the little that they did release. It's not a coincidence. It's intentional. It's about protecting one man, Donald J. Trump, from accountability. Release the files. I yield back.
Chair recognizes.
Mr. Chair, unanimous consent request.
Okay, I'll recognize you for that.
Mr. Chairman, I ask unanimous consent to enter the record a political article entitled "Clay Higgins Explains Why He Was the Lone No Vote on Epstein Files Release."
Without objection to order. Chair recognizes it'll be on our side, Mr. Perry, then Mr. McGuire. Mr. Perry.
Thanks, Mr. Chairman. I'm disappointed at where we're headed here. Look, I think that legitimately both sides want all the information. I know I sure do, with the proviso that the victims and innocent people are not damaged in the release of that. What's interesting to me is that the only time my colleagues on the other side of the aisle want to talk about any of this is when they can bring up the current president's name, but they're not interested at all in anything else. And I would just say this regarding the timeline, because I'm frustrated with it too. You know what would have been great? Would have been awesome if we could have truncated the timeline when the Democrat DOJ was in power under a Democrat president and there was any investigation whatsoever. Ladies and gentlemen, my friends on the other side of the aisle weren't interested in these victims at all when they could have done something about it. Nary a word was said, and certainly nothing was done. All this advance work could have been done by them had they cared. But this is not about caring about anybody. This is all political theater because they hate the current president of the United States. I get it. It's disappointing to me. These victims should have their day, and they should, all this information, regardless of who it touches, should be out, with the proviso that the innocent are protected. I know that's not of any interest to you. I get it. That's unfortunate. I yield the balance of my time to the gentleman from Louisiana.
I thank the gentleman for yielding. Mr. Chairman, earlier I asked unanimous consent to receive into the record the actual subpoena presented to the Honorable Pam Bondi by this committee regarding the DOJ's release of the investigative files on Jeffrey Epstein that was dated the 5th of August. I'd like to enter into unanimous consent associated with that entry, the letter written by this committee on August the 5th to Attorney General Pam Bondi, referencing the subpoena and giving specific instructions.
Without objections ordered.
I'd like to also enter into the record actually, I don't believe this has been released prior to right now, is the schedule associated with the subpoena. This is 1, 2, 3, 4 pages of specific instructions from this committee regarding the subpoena delivered on August the 5th. Now, unanimous
Without objection to order.
schedule as well. I'm sure the media will be fascinated with that. So the professionalism that this committee has pursued, to clarify for the citizenry, the professionalism that this committee has embraced and pursued has been squared away, impeccable. And that includes recognition that the Department of Justice, as stated in the subpoena, is to comply with redaction procedures of established law and criminal justice, long-standing procedures. So I heard someone mention 5 million files. That is the first time I've heard 5 million files. But I know that there were originally 250,000 files. And the Trump administration found another 600,000 files. So we were talking about, to round it off, 1 million files. Every one of those individual documents has to be reviewed by agents of the DOJ and their supervisors before they can be officially approved for release. That's the law. The DOJ has 400 agents working full-time on just releasing these documents. Now, you may argue that at the end of the day, you want to see the release of what they completed that day. I would say that's a fair narrative for discussion. But to say that DOJ is not fully engaged in complying with our subpoena is not accurate. It's not intellectually sound. And Mr. Chairman, I appreciate the opportunity to offer into the record these official and legal subpoena documents. I yield.
Without objection, so ordered.
Mr. Chair, I have a unanimous consent request.
Okay, Mr. Frost.
I have 2 articles. One is from Politics PA. Quote, Representative Perry referred to the House Ethics Committee for refusing subpoena.
Without objection to order.
The other one's a CNN article. GOP reps Perry and Biggs formally object to subpoena from House January 6th.
Without objection to order. Chair recognizes Ms. Crockett from Texas.
Thank you so much, Mr. Chair. I have sat here listening and I am quite perplexed. It does take me back to my legal days. And so when I think about a subpoena, one of the things that we normally look at when we are trying to determine whether or not contempt is going to be ushered into the conversation is whether or not there's been substantial compliance and what it means to actually look like you have substantially complied. It means that you're taking reasonable steps to follow a court order, that you're acting in good faith, and typically that serves as a defense. So if we are still crafting the parameters of said subpoena, for instance, my colleague, Mr. Walkinshaw, just asked whether or not this would be limited to the Epstein subject matter. For me, if they responded at all, then there is some sort of compliance, which they did. They didn't just throw the bird. They didn't just say, forget it. But more importantly, I just want to point out that we are living in an age of hypocrisy, because my other colleague just pointed out that Mr. Perry sits here and somehow sits in judgment of others. Frankly, that is what people are kind of getting annoyed by, is the hypocrisy, because Mr. Perry still has an outstanding subpoena that was never complied with. In addition to that, he talked about we need to care for the victims. Somebody correct me if I'm wrong, and I will yield my time. But I don't believe that Mr. Perry ever signed off on the discharge petition in the first place. So I don't know if he is just doing what he believes is politically expedient. But I will tell you this. I refuse to be a puppet, because Democrats tend to be of goodwill. We always want to do the right thing. We are always trying to follow the rules and follow the law. Unfortunately, we are living with an administration that does not care. We just want some type of parity. So, for instance, we all want to hear from President Clinton. If for some reason you said, we will give you, say, Pam Bondi, and then we've got President Clinton with it, or say maybe President Trump and President Clinton, 2 presidents, because we know that both presidents actually had a relationship with Jeffrey Epstein. But what looks political and looks like one can get away with everything, especially since that's what the Supreme Court has stated, that's why it looks like it's just gamesmanship. You only care about following the rules so long as you can invoke those rules on what is typically perceived as your political enemies. This is why we are falling apart in this country. We are supposed to be about checks and balances. It should not matter whether or not you're associated with the Democratic Party, the Republican Party, independent, or whomever, whether you're rich, whether you're poor, whether you're middle class, whether you're a black immigrant or whatever. But it seems like we only have a political agenda in this committee, and that's why everything goes off the rails. You only love law enforcement when they're going after black, brown, immigrants, that kind of folk, right? But on January 6th, you didn't care about law enforcement because they still don't have their plaques up. We continue to do the right thing and say, yes, apply the rules equally across the board. And then y'all play in our faces and you only apply it to one side. I am asking for one commitment and then I will yield to the ranking member. Mr. Chair, will you commit to me as the chair of probably the most important committee in this Congress, especially in this moment where people are concerned about the level of corruption that exists within this committee? Will you promise me that you are good for doing whatever is right and following the evidence, no matter who is on the other side of that evidence?
Yes, and that is why I subpoenaed the estate. And we had no idea what was, nobody knew. Nobody knew what was in the estate documents. And I, without hesitation, subpoenaed the estate. We subpoenaed the Department of Justice.
And that's where we got the birthday letter. We subpoenaed because the estate. Hold on, Mr.
Subpoena, right.
Okay, we got the birthday letter, but we can't just get the evidence and then not follow up on the evidence that we actually get. I will relinquish the rest of my time to the chair.
Thank you. I just want to just really clarify one. Thank you very much, Representative Crockett. Just to back to Mr. Walkinshaw's point, I think it's important to clarify that in communication, Mr. Chair, with your team and the back and forth with the emails, the Clinton team made it clear that they wanted to answer questions about Epstein, but that was not something that your team agreed to, only about Epstein. And so that's, I just want to make sure to clarify, and I appreciate you clarifying, Mr. Comer, that you said that you would limit the questions to only Epstein. Is that correct?
That is correct.
I think
what the Clinton said that is not true. What their lawyer said is a complete lie.
Well, I'm glad that you clarified for them, because it's been their impression that it's been. I'm just telling you, it's been their impression.
He's paid them too much money then over the last 5 months.
And sir, I'm not. I'm just reading emails, and I'm just reading the back and forth between them and your team. It's been their impression that those questions were going to be beyond just Epstein, and so I'm glad that's been clarified. So thank you, Mr. Walkinshaw.
Chair recognizes Mr. McGuire from Virginia.
Thank you, Mr. Chairman. I agree with you. 5 months is plenty of time. The Clintons are doing everything they can to avoid questioning. And the American people want to hear from the Clintons. You know, Bill Clinton brought Epstein to the White House 17 times. He had him on, and Bill Clinton was on the Epstein airplane 26 times. So the American people want to hear from them. I don't understand why our friends on the left can't understand that. They support these crazy policies like open borders, 20 million people coming to our country. They've been robbing, raping, and killing the American people. You know, Lake and Rowley would still be alive. And instead of protecting law-abiding citizens, they defend the criminals, and they want to have a defund the police movement. It makes no sense. These criminals they put back on the street, recommit the same crime, and they're like, why'd they commit the same crime? All Americans have the same goal, the same American dream. We want to live, work, and raise our family in peace. We just might disagree on how to get there, but the Democrats seem to always be wrong. The American people don't want boys undressing in girls' locker rooms, but for some reason, the Democrats support that. 5 months is plenty of time. The American people want to hear from the Clintons, and they said they had no relationship, but they definitely did. And with that, I yield the remainder of my time back to Ms. Luna.
Thank you. I just kind of wanted to point out, first of all, specifically to the letter, the hand sketch that was allegedly the president's. I believe there was a $10 billion lawsuit that was filed that, according to the president, the organization that published that is actually trying to currently settle. So just to clarify. But aside from that, I wanted to actually ask Mr. Min a question, if he's here still, if he would be willing to vote for a contempt in the Clintons if they refuse to come in and testify on a fine of about $1,000 a day until they comply with the subpoena. But I don't know if he's here. Is he still here? No. Okay. Well, I think that that's just something to consider. We have the ability to do those fines, and I think that that needs to be considered, especially if, optically there is reason for pause for Democrats not wanting to vote for that based on the fact that President Clinton was a former president. I understand the optics of that, and I also understand re-elections. However, nonetheless, the Clintons are defying a subpoena, so sometimes financially people can be motivated, especially if there's a fine, and that's something that we actually all reserve the right to vote on. And I think that that's actually a very good option, especially being that most Americans would go to jail for defying subpoenas. And so I do not think that there needs to be any special accommodations made, especially given the nature of this, but I do think that that can be a tool to motivate. So I'd like to suggest that to you, Chairman Comer, also to you, Ranking Member Garcia, that would be a good method that we specifically reserve if we choose to use alternative means of contempt.
Representative, would you yield to me for a question?
Yes.
So it seems like you're open to changing this, what we're voting on today, so that way we can get to a place where we actually hear from them. Is that right? Is that what I'm hearing?
What I want, yes, I would like to have the Clintons coming into Congress to give a transcribed deposition.
Yeah.
I think that Chairman Comer has made that clear, but I also think having just Garcia and Comer drive all the way up to New York without that, I think that optically that sends a very bad message as the separation of powers and authorities Congress has. And then I also too think that it's kind of a slap in the face to people that typically would not have those accommodations made for them.
Yeah.
With that also, being a part of this, I think that, Bill Clinton specifically said he wants the files to be released. And I think that we also need to consider the fact that there is a judge. I know Mr. Garcia disagrees with me on this, but based on the email that I have seen on Judge Paul Engelmeyer, if you have someone that is ordering the DOJ to do a second scan of the files, if it's politically